President Trump is wading into another war, this one being fought in Texas over whether burger joints can use terms like Trump burger, the MAGA burger, the Trump MAGA burger establishment. Is that allowed? Can you do that, or is it a violation of trademark or his right to those words? John Rizvi is the patent professor. He's a professor at Nova Southeastern Law School in Florida, and he's the author of 2 books on patents. John, Professor, thank you so much for being with us.
Yes, always a pleasure. Thank you.
Let's start with that most basic question. Can burger joints sell burgers called the Trump burger or the MAGA burger?
So actually, the Trump organization's in a really strong position here. They have used several marks with the Trump name. They have several trademarks registered, have use of Trump Grill, Trump Cafe, Trump Pizza, Trump Sweets, and anything that this burger joint is doing creates this confusion among consumers that they are somehow affiliated with Donald Trump or one of his organizations, and that's not the case. So they are on pretty strong grounds from a trademark standpoint to stop this usage.
Why burgers? Is it because this could be consumed and someone could get hurt and then the president could be responsible? I mean, there's so many other things that are sold with his name on it.
Well, it's not just would be a concern with burgers, but any usage dilutes the strength of the Trump name. So if he does not, or any trademark holder, if they don't enforce their trademarks in one type of goods or services, they start losing the ability to do that in others. So the concern might not necessarily be that burgers are any worse than any other infringing product, but if they don't take action, then that dilutes their trademark rights. So they are in a position of either enforce your rights, police your trademarks, or you start losing protection for all of your brands.
Can you argue, Professor, that the term MAGA is primarily informational or ornamental? Should it be allowed to be trademarked?
So interesting point there, because there is under, the First Amendment, of course, you want to encourage free speech. You want to encourage people to talk about things, speak about movements, certainly such as MAGA, for example. However, once there's commercial use, and that's where the weakness comes in from this restaurant, is that it's for-profit commercial use, and First Amendment protections are limited in cases like that because it's seen as commercial enterprise, and you're confusing consumers as to the origin of the product.
Couldn't this be great advertising, though? I mean, why is he mad about this?
It could be, and I think that's the balance that a trademark holder has to have. They on the one hand, they benefit from this usage. On the other hand, the longer they let it go, the weaker their protection, because it allows the next person to come forward who may have something that's even more objectionable, but then the Trump organization has weakened rights because they didn't take action in this case. So it's a use it or lose it type of protection under trademark law. You're under a duty to police your marks. If you're going to register and file for the trademarks, have them granted. You can't not enforce them without losing those rights and weakening the protection in the future.
Professor John Rizvi is with us on WTMJ. So here at the radio station, Professor, Julia and I are allowed to talk on the air about the Super Bowl. We're allowed to talk on the air about March Madness. We're allowed to use those terms in that way, but I'm not allowed to let one of my advertisers use the term Super Bowl or March Madness or to benefit financially from it. Is that the same sort of thing that's happening here?
It is. Once it becomes commercial use and it's for profit, and it's not something that's done for news or for educational purposes, then First Amendment protection for that speech is limited and is not nearly as broad as it would be, say, if someone's writing an article or a radio show about and using those marks as part of their commentary. That's completely different than if you were to start commercializing and somehow financially gain from using trademark terms.
You know, Professor, I agree. If anyone wants to protect their identity, that's fine. But this is the President of the United States. How is that possible?
Oh, yeah. So your question is how is the president able to file for these trademarks?
Yeah, especially when it's in a political campaign and it's history, and some people are just referencing it, and it's in our culture. It's in part of our American history now.
So you bring up a good point. The Constitution restricts presidents from profiting from foreign governments or additional compensation for themselves through the U.S. government, but there are no restrictions on private business. That doesn't mean that this is not fraught with ethical and political risk, because certainly a lot of Donald Trump's trademarks, for example, America 250, and a lot of trademarks using 250 for the 250th anniversary of the United States, those are seen as kind of blurring the lines between his role as the president and his private companies that are the ones that are filing and obtaining these trademarks. So it is something that is likely to possibly face issues. There's one particular trademark for Donald Trump International Airport that I believe is going to become problematic if there eventually does not, that there is no airport with that name, because then that trademark could be denied as being misdescriptive, deceptively misdescriptive, because the thing doesn't exist. And so some of his trademarks are filed in advance. They're called intent to use trademark applications, and the organization is looking to the future. But if what they're hoping to pass doesn't happen, then the trademark is likely not to be granted on that basis, that it's deceptively misdescriptive. And the test is simple. Is it something that misdescribes the goods or services? And number one, and if it does, are consumers likely to believe it? And so that's put some of the trademarks at risk as well.
He's also known for another word before he ran for president. You're fired. He tried to trademark it. Do you think it went through or it didn't? John?
I think no, he was not successful.
Professor, do you know?
He was not successful.
He was not. Very good. Very good.
Why? Is it just too common a phrase?
Mm-hmm.
It's well, even common phrases, if they are used to identify a particular good or service, are okay. Like, for example, Apple. Apple is a common phrase, but they're not selling apples. The company is, focuses on initially, computers and now cell phones and electronic devices. I don't recall offhand what the concern was with "you're fired." But perhaps it may be that it's not associated with a particular good or service. You can't just take words of the English language out of the English language completely. You are permitted to use them to sell goods or services, and so the rights are narrow. For example, Uber is a word that exists in the English language. One company, Uber, owns it specifically for transportation services, but that does not give them exclusive rights to prevent anybody else from using it in a different class or for different types of goods. Dove is a type of a bird. But there's two companies that use that term, one for chocolate and another company owns that exact term for beauty products, soap and moisturizer, things of that nature. And all of that's permitted because it's tied to specific goods or services. And Donald Trump's trademarks are tied to goods and services as well. So it's not as if he's claiming exclusive rights to use America 250 or 250, but they're tied to specific products that are for sale.
John Rizvi is the patent professor, teaches law at Nova Southeastern Law School in Florida. Thank you, Professor. We appreciate it.
Thank you. Always a pleasure.